Underage DUIs in South Carolina depend on a few things. If you're under 21 and you receive a DUI, the inference level, we've heard of the .08, everybody talks about the legal limit, we call it's an inference level under the law. It's lower for underage people. And at certain ages, let's say you were too young to have a driver's license and you got out and were arrested for a DUI. At that point in time, you would go through a juvenile court as opposed to a criminal court. The juvenile criminal system in South Carolina, even though it closely resembles the adult criminal law system, is not technically a criminal court. What it is a civil court where if a child is deemed to be delinquent, then they fall under the jurisdiction of a family court judge. That family court judge, for pretty much any violation, because it's non-criminal, can still send a child away to a place where they're locked up, similar to a jail, put them in a diversion program, or send them to these camps that we have around South Carolina, which are really interesting. Each one has a different theme for different periods of time. But you could potentially go into the custody and control of the Department of Juvenile Justice till you're 21, which is a pretty big difference. And once you're of age, but yet underage, you would be handled in the criminal courts just like an adult. It would just be that the level of alcohol that would be required to prove that you were driving under the influence or that you were materially and appreciably impaired would be lower. If you have any questions whatsoever about your DUI charge, or if you're charged with any criminal offense in South Carolina, particularly driving under the influence, give us a call. We're your lawyers at the beach, and we're always here to help.